So today we discuss the arraignment of accused person at trial and the plea of guilty during the arraignment. So you know that under criminal trials, part one, when we learn about the arraignment of an accused person at trial, one of the ways that the accused person can respond to the plea, to the charges read against him, is to enter a plea of guilty. Now, let's see how the court responds when he enters a plea of guilty. Now, if he enters a plea of guilty to a capital offense, and what the court will do would be to enter a plea of not guilty and then proceed to have the trial. All right, because the court would not just convict and then sentence a person to death because they have pled guilty upon arraignment. All right, they still have to be tried for their guilt to be proved. So if it's to a capital offense, an offense that carries the death penalty, the court would enter not guilty and then proceed to trial. If, however, the plea of guilty is to a non-capital offense, and what the court would do would be first to record the plea of the accused person, all right, in the same words used by him, and then would invite the prosecution to state the facts of the case to the accused person, and then the court would inquire from the accused person if the facts stated by the prosecution are accurate, right? If his plea is to those facts stated by the prosecution, and then the court may now proceed to convict and sentence him. All right, if the court fails to follow this procedure, then again, that conviction will be a nullity. Now, you see that specifically with offenses that require scientific proof, all right? So offenses in which in order to prove the facts, you need to provide some scientific evidence, like drug offenses or counterfeiting of currency. All right, these are offenses where you need to prove the facts of what you've stated. For instance, if you're claiming that some whitish substance is cocaine, you need to show a lab report, a test result showing that that substance was tested and has been proven to be cocaine. If you're claiming that currency is counterfeit, you probably need to show some expert evidence pointing out, the discrepancies between that currency note and an authentic currency note. All right, so for offenses like that, for offenses that require scientific proof, it's not enough for the prosecution to simply state the facts. The prosecution would also need to provide some scientific proof, all right, before the court could proceed to convict and sentence the accused person. All right, then finally, we also have a situation where an accused person enters an ambiguous plea of guilty. All right, for instance, in the case of Aremu and COP, the accused person in that case entered a plea of guilty with reasons. Now, the court cannot proceed on an ambiguous plea, all right, it's incompetent. And so what would happen would be that the court would ask the accused persons to take his plea again, all right, because an ambiguous plea is not competent for the trial to continue. All right, so those are three possible scenarios you can come across, all right, where you have a plea of guilty to a capital offense, in which case the court would enter not guilty and proceed to trial, where you have a plea of guilty to a non-capital offense, in which case the court would first of all record the plea, ask the prosecution to state the facts to the accused person, ask the accused person if his plea of guilty is to those facts, and then proceed to convict and sentence him. And if it's a drug offense, they would need to provide scientific proof as well of the facts. And then finally, where you have an ambiguous plea, in which case his plea would have to be taken again because the court cannot convict on such plea. So I hope you learned something useful again today, and bye for now.